Good morning, good afternoon, good evening, whenever you're watching this. Not legal advice. Like, subscribe, share, invite your next door neighbor out to dinner, do something. Um, Starting off with a joke today. Um, Somebody told me that culinary school was going to be very difficult, but the final turned out to be a piece of cake. Thank you for that one to Anonymous. Anonymous, thank you. What a nice job. So I indicated, I think, yesterday, I was going to go back and summarize MMTL litigation after I had a couple days to consider it, and that thereafter we could take a little journey on arbitration, and I would take you through my arbitration as a hopefully as a learning experience to learn from any mistakes that are made, to probably in the future help you get through potential arbitrations, etc. Anyway, so we'll deal that on a step-by-step basis. I'm going to try to break this stuff up because it may involve new terms, vocabulary, and things. So I'm going to try to cut it up into pieces, shorter videos, shorter relatively. So just kind of bring you back to where we're going to start. So a couple days ago, this week, the federal court issued orders in my case, and the case is pending in the Central District of California in the federal court there. And there's numerous of these federal courts throughout the country. I think there's 94 districts throughout the country. So this ruling is, I think, the first final ruling in any of the current 5 cases that are pending. There may be future ones, and I alluded to that. But I wanted to explore the status of mine in particular. So in my case, there were about 75 filings to date in federal court. Now, obviously, the matter continues on and will continue on until there's a resolution. So what the court did is, earlier this week, they issued a decision on the merits, which is the substantive decision. Most of the things that you've heard to this point in time involve procedural matters, including other attorneys. Like Rose's case, she has a motion to amend. So that's a procedural, not a substantive motion. And most motions are procedural, as it turns out. And also there's a pending petition by Mark's office for blue sheet documents. That would be also considered to be, I guess, a procedural motion also. But that's pending, and I think that'll be heard on the 30th. So anyway, in my action, the court made a decision as to Fidelity, that they retain jurisdiction over Fidelity. In other words, that the court will be monitoring any arbitration involving Fidelity. I've contacted counsel for Fidelity. I've indicated I'm intending to move forward. I've begun preparing a claim form, which I will go over in a subsequent interview, subsequent video. But the claim form sets forth what your claim is. And as I've indicated elsewhere, my claim doesn't just involve securities violations, it'll involve state claims too. I've kind of informed Fidelity of that for quite some time. So I'm working on the claim. The damages will be different than just lost value, because the state claims have different damages. But we'll go into that as I file them so you can see what I'm doing. And by the way, not legal advice. This is just me doing what I'm doing. So that's that part. I'm considering filing a separate action. I haven't really decided about this, but I've thought about it, involving MMAT against Fidelity also. Now, the point about this is, whereas I have an arbitration agreement with Fidelity and I bought MMTLP stock in a Fidelity account, my MMAT stock is in a different stock at a different brokerage, and I don't have a contract with Fidelity as to that. So theoretically, there is no arbitration provision that would govern any claims I might have regarding MMAT. and the actions that Fidelity might have done to impact that security. And I believe I could file a separate action on that. I've contemplated that. In essence, their action as to MMTLP harmed and is continuing to harm my interest in the shares of MMAT. So I'll let you know what I decide about that, but I was just thinking about that, and it would be unexpected, I believe, by Fidelity, or at least unexpected before this video, but I'm happy for them to consider everything. Discovery in a FINRA arbitration in this particular matter will be very interesting. It'll be interesting because FINRA has been accused of criminal conduct. So even though they're not the ones who are the actual decision makers in a FINRA arbitration, it's under their auspices and management, and the arbiters, who may be members of multiple panels. In other words, there's not like 3 or 4 arbitrators. There may be hundreds or thousands located in various geographic areas throughout the country. They may serve on multiple panels, but they may get income through FINRA, and that's an interesting position to them to be in. Also, I intend to try to take the deposition, for example, of Mr. Sam Draddy. Draddy, as you recall, is the chief, basically the chief cop of FINRA, and he was a former senior counsel at the SEC in the enforcement division. So he's an important player, excuse me. And he was involved, and he's referenced in the 2021 email and the 2022 emails. So he's a member of FINRA. FINRA would issue subpoenas, and we'll get into this at another email also, another video also. FINRA will issue subpoenas for depositions, but they have to agree to do that. FINRA being within the FINRA arbitration. So there will be arbiters conducting an arbitration. To get a particular deposition, you have to have the arbiters approve that. And it would be an interesting situation if we were asking arbiters that were hired by FINRA to make a decision to let us depose somebody from FINRA. That to me sounds like a very conflicted situation. Additionally, the same would apply as to the blue sheeting. We could ask, but their decision would have to be made by arbitrators that are paid by FINRA. So I am going to, when we get to that spot, I'm certainly going to make an issue of that and make them aware of that. But obviously you could see that there will be confusion and conflicts involving discovery that has to be necessitated by people that are working for FINRA against FINRA. And I will deal with that. As to the FINRA and DTCC ruling by my court, they found no liability as to the issue of the damage issues. They made no decision related the issue of immunity, non-monetary issues, other than they said that I was not entitled to an accounting as against them. But as to other non-monetary issues, they appeared to leave that open and didn't make a decision as to that, although they recognize that is an issue. And I know I've communicated that through people to Rosa, because I think she's in a position where she would not be seeking monetary relief, and it might be helpful for her case. So I'm considering new action because the court left open the idea of non-monetary actions being exempt from immunity. I have considered filing action in state or federal court related to declaratory relief, and it might relate to obtaining transactional documents, blue sheets, etc. And we would likely litigate the issue of immunity, I think, unless the case got moved to federal court, which there may be an attempt, and then we would litigate it there, likely before a different judge if it's a new case, but not necessarily. And I haven't decided. So I haven't decided if I'm going to file an appeal of the case that dismissed both FINRA and DTCC as to immunity in general, or as to just the monetary claims because of the criminal allegations of criminal conduct, or file an appeal and pursue a declaratory relief action on non-monetary grounds. Haven't decided that, but I'm thinking about it. But they won't be involved in the arbitration. So the arbitration against Fidelity is going forward, and I've already notified, again, Fidelity of that. And the action against FINRA would either be an appeal or a new action, and I'm contemplating both, and obviously we'll let you know that. And I'm not sure about the DTCC, haven't decided. The ruling came down, this week, so I have a little time. I'm going to probably make that decision as to FINRA and DTCC within the next week or two. And I'm going to start the arbitration, the filings probably next week. So what I intend to do is after today's video, I'll make another one dealing with specifically the arbitration, and we'll start to go through the process. And you'll attend, at least virtually, through me and through whoever else will end up attending and participating. But you'll get a feel for the process. As I mentioned, the process is private. However, the proceedings themselves are recorded, and those recordings are available, and they can be transcribed also, like you see in court. So we will be able to follow on as it goes, and learn and find out what goes on. I will be back with more in a day or two. Remember, in the end, we've always thought that the broker-dealers were the most at risk, and nothing has changed besides the other stuff that's going on in the background. Anyway, so I hope that puts it in better context. So to summarize, arbitration against Fidelity, against FINRA, DTCC, considering appeal of monetary immunity issues based upon criminal misconduct, considering filing new action on the non-monetary claims for declaratory relief in either state or federal court. That'll summarize. And again, next week we'll start, or sometime, we'll start with the arbitration. Have a good day. Be well.